Thank you, Joe. I know we're under a bit of a time constraint here, so our next speaker I've been asked to help out by introducing her, and I will in a couple of minutes. Joe asked me to say a few words because I guess there are some people who wonder what kind of work I do. They've got my card, Canada Court Watch. There was a good, Dr. Darnell mentioned a while ago about crisis bringing people together. And you know, that kind of struck me a few minutes ago. And one of the things I see, I think everyone in this room has been brought together by what could be called a crisis. And I will look at it from the perspective that we have. It's about injustice. PAS is about injustice. And I think we've all been struck, and this is what motivates many people, is that they take up a common cause. PAS is a cause. And Joe wanted me to take a few minutes just to explain how common causes evolve into people doing things and motivating people, which the people I've talked to today are all motivated by something in their life, such as a crisis, just as I have. I guess back in about 1995, I went through divorce, and I went into court with reports from 2 child psychologists stating that my daughter was at severe risk of harm at the care of the mother. There was already a history of abuse for the children's aid, 2 inches thick. She had threatened to kill the children. I walked into court, and even though there was no countering professional reports, the judge handed sole custody over to her. That was my first taste that there was a problem with the court system, and that motivated me to wonder what's going on and why this occurred. For many years, I had a small daughter who was very young, just in her first year. Used to come and describe how she had to hide in the closet, how she would be beaten. She would come with bruises. Nobody would do anything. Unfortunately, those horrors, we managed to get through it. There's been, certainly harm done to the children as a result of that. But that crisis in my life motivated me to do things and to get on to work. And back in about 1995, I actually started to work on a concept I have called hostile aggressive parenting. And it was a phrase that I believe I may have been the one that coined it. It's called HAP. You can do a Google search on the internet, you'll find it. And I started writing papers based on the behavior of parents, because I started to meet other people in the court system. And from that, I evolved some documents on hostile aggressive parenting. In a few years later, I developed a paper called the Risk Assessment Protocol on Hostile Aggressive Parenting, which is a scoring mechanism, which I believe, even though I didn't know much about PAS, it's kind of the behaviors that many people are talking about today. Well, anyways, this motivated me to get into mediation. I started helping people, and through my crisis, became to know and meet very many people, many of I see here today. One unfortunate thing that I found is that when I tried to help people by mediating or going into the court and trying to help people, there was a sudden realization came about one time, is that I found that many of the judges and those in the legal profession did not want solutions. They did not want to hear from people in the community that knew what the truth was. So I changed my tactic, and eventually we formed an organization called Canada Court Watch, where we now go after issues of accountability, transparency. We investigate judges, we report on judges, we report on social workers, we report on these people that you all know about who are out there doing bad work and harming children in the process. The organization itself is headed by the Archbishop Dorian A. Baxter, who I work under, and he was the first person in Canadian history who successfully sued a Children's Aid Society and won. It was a historic case. His case is mentioned in the Archives of Parliament, and he won a case against the Durham Children's Aid Society. And he's the head of our organization. But anyways, over the years, through my involvement and through Canada Court Watch and Family Conflict Resolution Services, where I started, I've met many people. Some of them are here in this audience today. And I've seen other organizations started up, and I've met other organizations. Which brings me around to the, I guess, the next speaker. That I think it was probably 10 years ago, I was one of the speakers at the Joint Senate House of Commons Committee hearings. And I met the next speaker, who is Gwendolyn Landolt from Real Women of Canada, and I'm going to introduce her in just a second. But we were co-presenters at that time, not together, but she presented, I think, very close to when I presented, and we first met there, and I got to talk to her personally. I think there were a few other times when I've met her at other functions where she represented the Real Women of Canada. One thing that impressed me is that her work, and although I haven't worked closely with her over the years, certainly the times that I have met with her and have seen the work that the Real Women of Canada have done, I can say it's certainly impressed me and impressed many people that their interests are truly for the interests of children and, from our perspective, from the issue of justice. And it gives me great pleasure to introduce Gwen here, and I'll give you just a little bit of a, because Joe just asked me, I didn't bring my reading glasses here, but I'll do my best here. Gwen was graduated from the Faculty of Law, University of British Columbia, Canada, and was called to the British Columbia Bar. She has had extensive legal experience in private practice as a Crown prosecutor and lawyer with the federal government, where she specialized in immigration and Aboriginal affairs. Gwen has written extensively on constitutional issues, in particular the Canadian Charter of Rights, and has participated in many cases before the Supreme Court of Canada on pro-life and pro-family issues. Gwen is one of the founders and is currently the National Vice President of the Real Women of Canada, a national women's organization founded in 1993. So it gives me great pleasure to have Gwen come up here and speak.
It's a great pleasure for me to be here to speak to you today. I hope I'm not going to be too dull in comparison to some of the other previous speakers. People find law very boring, but it really is the framework of which you're going to find yourself in, and everyone has to know what's going on in the legal sphere. It's vitally important to know where you stand in the law, and I'm trying to give you some ideas how parental alienation syndrome has been affected by the legal system in Canada. The one thing that we know with certainty is that children need both a mother and a father to grow up to be well-integrated, stable personalities. Otherwise, no matter the circumstances, either by design or ill fortune, such as the death of a parent, there is a wound or loss within that child that does not heal, even over time. Divorce and separation, made so easy today with no-fault divorce, common in most jurisdictions, has permitted parents to separate for reasons, valid or otherwise, and thus made existence much more precarious for children of that marriage. Even though the parents have parted, there should be no separation of a parent from his or her child. Unfortunately, legislation, policies, and judicial decisions have, over the years, perhaps unintentionally, often encouraged one parent to alienate a child from the other. Usually this occurs in regard to the father, but this is not always the case, as we know. This alienation of a parent leads to permanent harm in that child's life and quite correctly be described as child abuse. It is regrettable that PAS is frequently used as a tool for one parent to achieve sole custody of a child. The opportunity for PAS occurs because of loopholes in both our federal and provincial legislation, as well as by judicial decisions. For example, under federal legislation in Canada, the first thing and the first troublesome fact is the no-fault divorce legislation itself. In 1986, the Divorce Act was amended to provide for no-fault divorce. This legislation provides that a husband or wife may unilaterally walk away from marriage for any reason or no reason at all, abandoning both spouse and children. The consent or agreement of the abandoned spouse to this action is irrelevant, even though he/she may not have been at fault in any way in the breakdown of the marriage. Subsequently, a divorce is then easily obtained by the deserting spouse by simply living apart for 1 year. No questions asked by the court, and there are no consequences for the abandonment of marriage and family. That is, with ease, a spouse can walk away from marriage and unfortunately separate the other parent from his or her child in this process. This is because the divorce industry in Canada has put machinery in place to facilitate the fallout from a divorce, and it is this machinery that facilitates PAS. The latter is available to a parent who wishes to use the child to harm the other parent. And despite a deserted spouse's unhappy experience emotionally and financially with no-fault divorce, the real losers, as we know in this matter, are the children of that marriage. Single parenting is not good for children. Marriage serves the all-important function of providing the ideal conditions for rearing children. Without an intact family, children learn their gender. Within an intact family, children learn their gender identity and roles. Hundreds of studies have been done on children in psychology, social science, economics, medicine. In every way, scientists have determined that children do far better when their parents are married and they stay married than in any other social arrangement. Empirical research in family and crime also strongly suggests that crime is closely linked to family structure, which is the strongest predictor of urban violence. That is, the absence of fathers as models and co-disciplinarians contributes to the lowest self-esteem, anger, violence, and peer bonding through gang membership of many fatherless boys. The increased incidence of serious violent crimes by youth in Canada, particularly in Toronto and Vancouver, such as homicide and armed robbery, is in fact directly linked to this absence of a father's constant presence and influence. This is not to suggest that mothers, the majority of single-parent families are headed by mothers in Canada, are irresponsible or incapable of caring for the children. Rather, they are often overwhelmed by the difficulties balancing paid employment with family responsibilities while living in a reduced income. Exhaustion, lack of home time frequently precludes the disciplining of children and is a reason for the loss of control over them to their peers and youth gangs. But the greatest problem in Canada now for PAS is caused by the application of the Criminal Code of Canada. Provisions in the present Criminal Code provide an increased opportunity for parental alienation syndrome. This is due to the fact that it is the policy of most provincial attorney generals that an accusation of domestic violence requires both police and Crown lawyers to prosecute under the Criminal Code with vigor any spouse alleged to have engaged in domestic violence. It is troubling that under this criminal process, the complainant can achieve by court order total custody of the matrimonial home and custody of the children. This, of course, means that the accused is barred from the home, prevented from exercising custody or access to his or her children without any considerations of the factors of a family court. The family court, as you know, uses statute and case law usually to define the best interests of the child. The criminal code, however, can wreak havoc on the family and in particular in the children, as the Canadian criminal justice system pays no attention to the best interests of the child. There is no remedy short of bail review of the accused. This places one party in a position of immediate superiority over the other party for as long as it takes, perhaps a year, for the criminal charges to be resolved. During this period, the child of the marriage usually has no contact with the accused parent. The period of incarceration or terms of bail usually provide the uninterrupted opportunity for the custodial parent to encourage alienation of the child from the other parent. The stigma attached to the alleged domestic violence and the resulting charges also exacerbates the alienation of the child. It is troublesome that the accused parent can be arrested for domestic violence and child abuse even if no evidence is presented. In fact, A custody order can be made and put in place, plus child support payments ordered. Again, no evidence required, only the accusations of a spouse. The latter, of course, can use these accusations of domestic violence and child abuse for a tactical advantage in the struggle for custody and support. This tactical advantage, however, is not usually as available to men as it is to women, given the fact that when domestic violence is instigated, it is presumed incorrectly by police and justice system that the male is responsible and should be removed from the home. In fact, studies indicate that women instigate domestic violence as frequently as men. Our federal child support guidelines, of which most people are laboring under, although it did have a good intent with regard to providing support for children, it came in effect in 1996, and its purpose was to promote objectivity and consistency in child care awards in order to lessen conflict and tension between the separated partners. Before the implementation of these guidelines, however, courts were able to take into account the level of access by a parent who may have been alienated from his child by the other parent. This had had an ameliorating effect on the custodial parent, which prevented him or her denying access to the separated divorced spouse. Under the guidelines, however, the support must continue to be paid, even in circumstances when court-ordered access has not been honored by a parent. That is, the reality is that court-ordered access is seldom enforced in Canada, and the parent who has been alienated from his child has no particular practical remedy except by way of costly litigation for a court order to enforce the access order. This option, however, is often not available and out of reach of parents financially struggling to maintain two residents and child support as a result of the separation. In addition, practically speaking, punishing a parent for violating a court order for access is fraught with difficulty because it also hurts the child. Similarly, although the Canadian Divorce Act specifically recognizes the importance of having both parents involved in their child's life and mandates maximum contact if it is contrary to the child's best interests, there is no provision in the Divorce Act to protect a parent who has been alienated from his child by his spouse. The general provisions of the Act protecting the rights of parents' access to their children, therefore, are merely illusory. The point should be made here, however, that even if there were penalties included in the guidelines in the Divorce Act to protect a parent who has been alienated from his child, it would still not address yet another problem, that of a less than ideal parent being permitted to walk away from marriage without any consequences. Under the no-fault divorce legislation, if that person has little or no interest in having access to her child, then there's no compelling, at least legal reason, such as a penalty, for that disinterested person to contact the child in that marriage. But child custody is also constantly a problem. According to Stats Canada in 2004, the last available, custody is awarded to the wife in 45% of cases, while fathers are awarded custody in Canada in 8.1% of cases. In 46.5% of cases, custody is awarded to the father and the mother jointly. However, under a joint custody arrangement, children do not necessarily spend equal amounts of time with each parent, but rather one parent retains physical custody, usually the mother, and the father is left often with relatively infrequent access rights, despite the fact both parties are supposed to have equal say over the child's upbringing. Thus, even in cases of a joint custody, there is ample opportunity for a parent to alienate the child from the other parent. But we have other problems under our provincial legislations. The Family Law Act of Ontario is very troublesome. Because it can create a double jeopardy scenario for a parent in PAS, in that not only does the federal criminal code provide an opportunity for PAS, but provincial legislation also provides this threat into the Family Law Act. For example, the Family Law Act of Ontario, which has been the flagship for family law in Canada, since most family law acts in Canada pattern themselves after it, it includes provisions that are easily provide the opportunity for PAS. This is highly regrettable, since the intention of the Family Law Act is to protect spouses in the controversial issues of custody and access arising from the separation. The preamble to this legislation provides for, quote, equitable sharing by parents of responsibility for their children, unquote. But the devil appears to be in the details, since the Act also includes provisions that work against the preamble. For example, the legislation specifically provides in Section 24 that a court may direct the one spouse be given exclusive possession of the matrimonial home, and also under Section 24 direct that all contents of the matrimonial home remain for the use of the spouse given possession. In making an order for exclusive possession in Ontario, the courts under Section 24, subsection 3 of the Act must consider the best interests of the child. But to determine the best interests of the child, the courts must consider the disruptive effects of the child if moved to other accommodation, as well as the child's own views and preferences. The child is thus placed in a very difficult situation. He or she may be concerned by any subsequent rejection by or a moody reaction from a parent that he or she does, if she or she does not reject the alienated parent as required by the custodial parent upon whom the child is dependent. This is especially the case when the parent decides to use his or her child to punish a former partner. Unfortunately, the Act also provides for ex parte restraining orders, which in law means it does not allow the other party or opportunity to defend himself, and thus it is another tool to provide PAS. The problem with restraining orders obtained in civil jurisdiction, which is the provincial legislation, rather than the federal legislation criminal code, is that in civil proceedings, the proceedings are privileged and shielded. Also, civil proceedings require a lower standard of proof, that is, a balance of possibilities. In criminal proceedings, however, a higher standard of proof is required, that is, beyond a reasonable doubt. It is noted the Ontario Provincial Attorney General announced on November 24, 2008, that the Family Law Act would be amended to require breaches of restraining orders to be prosecuted under the criminal code rather than under the provincial legislation. This amendment will mean not only a higher standard of proof, but also define breaches of restraining orders as a criminal offense, which we know will result in very severe consequences. Therefore, when there's a restraining order against a parent, they're going to be in deep, deep trouble if this legislation, which apparently is going to be pushed through, becomes law. The Children's Law Reform Act of Ontario is also very problematical. It does provide positive provisions that the mother and the father of a child are equally entitled to custody of the child. Further, it includes the very salutary provision that when parents are separated and the child is in the custody of one of them, the other is entitled to access the child, and each shall, and this is a quote from the legislation, which sounds great, encourage and support the child's continuing parent-child relationship with the other. Moreover, it says that access to a child includes the right of a parent to visit and be visited by the child, to make inquiries and be given information as to health, education, and welfare of the child. One would think that those provisions would be ample to protect an alienated parent. However, these excellent broad provisions are unfortunately overridden by specific provisions, such as Section 24, which provides that custody and access to a child shall be determined on the basis of the best interests of the child. That's an important consideration. However, Section 21 provides the determination of best interests of a child includes the love, affection, and emotion between the child and the person claiming custody, the persons involved in the child's care and upbringing, and also the child's views and preferences. In circumstances of PAS, these particular provisions act as a strong deterrent in obtaining custody and access, especially when children, in order to retain the support and love of a custodial parent upon which the child is dependent, may be genuinely fearful of repercussions by the custodial parent if the child expresses any support for the alienated parent. Also, a very troublesome section of this Act is that the court must look in assessing a person's application for custody is whether that person has at any time committed violence or abuse. That's very reasonable on the surface. However, and then Section 34 provides denial of access to a parent will be justified if the child or spouse might suffer physical or emotional harm if access is exercised, and if so, the court may order a restraining order against the alleged abusing parent. This raises a terrible problem we have of false allegations. The latter have been described by Senator Ann Cools, an expert in family law, as a heart of darkness. That is, falsely accusing the other party, usually fathers, of sexual or physical abuse is a lethal weapon in the business of parental alienation and achieving sole custody of a child. Countless accusations of child sexual and physical abuse, over 50 cases I counted in just recent years, have been proven in court to be false. In 1996, the Manitoba Civil Justice Provincial Task Force reviewing false allegations so as to obtain sole custody of a child reported the task force heard horror stories about the traumatic impact on the accused person, on the immediate family and children affected by malicious false allegations designed to achieve sole custody, prohibit or restrict visiting privileges, and to punish the other parent. In short, the provisions of the Family Law Act and the Children's Law Reform Act, albeit unintentionally, do create and can strengthen opportunities for unscrupulous individuals, either male or female, to manipulate the law to create PAS. I will say that the Canadian courts have risen to become much more aware of the problems created by PAS than they have in the past. And they are trying to make, in recent years, a genuine effort to remedy the situation. The first one that comes to mind was in January of this year in the case of AL and KD, Ontario Superior Court, and the court ordered the child taken from the mother, who was a strongly alienating parent. This is reassuring, since previous custody disputes in Canada have not taken PAS into consideration. The fact that the courts in few recent cases have stepped in and removed the offending parent from having custody of the child and banning contact with that parent may well be a wake-up call to prevent the mischief of PAS in the future. This understanding of the reality of custody difficulties has not always been prevalent in our courts. For example, in 1991 in Ofield versus Ofield, Mr. Justice Blair of the Ontario Court of General Division denied the father custody, although he had a loving and close relationship with his children. The judge concluded, however, that the mother may remove the children to France with her in order that she could live with her boyfriend. He stated to page 238, "Is it in the best interest of a child to make an order which effectively defeats this prospect and leaves them in daily care of a mother who loves them dearly but who is shackled by her discontent?" It is interesting that the mother's marriage to her boyfriend in France never did take place. But the decision reveals that the court regarded the mother's personal happiness over the children's need of a close relationship with her father. And then to add insult to injury, Mr. Justice Blair, in a later decision, ordered the father's support payments to be increased in order to cover the cost of the children's trip to visit him in Canada. Another example of insensitivity in the to the non-custody parent's concern was the Supreme Court of Canada Justice decision in 1998, when Madam Justice Claire Heroux-Dubé, who from her many decisions can be very accurately described as a feminist-only judge, wrote a lengthy judgment in Young versus Young, in which she asserted that a child's best interests were best served by protecting the position of the custodial parent. According to her, the role of access parent is that of a very interested observer, giving love and support to the child in the background. This is scarcely reassuring to a parent alienated from a child. To be defined merely as an interested observer is a denial of the important role of both parents in the raising of the children. So what can we do with this legislation that is causing trouble and the loopholes leading to PAS? And it seems apparent that provincial legislation that I mentioned, which would be the same in all the provinces, although I'm dealing with Ontario, it should be amended to include a specific provision to the effect that if it is shown that a parent has alienated a child from his or her parent, then custody and access will be denied that parent, since PAS is clearly not in the child's best interest. It is not sufficient that is happening now, the protection that PAS be left to the discretion of the judge only. Rather, it should be a requirement written directly into the legislation that if also, in addition, it is imperative that allegations of abuse under the criminal code be supported by evidence before the charges are laid. That is, statements by a spouse of abuse should no longer be regarded as sufficient to support a complaint under the criminal code. And moreover, the federal support guidelines should also be amended so that child support payments be adjusted upon evidence of PAS. Similarly, the Divorce Act should be amended to provide at the very least the no-fault aspect be expedited and available only if both parents want the divorce and are able to negotiate mutually agreeable arrangements regarding child custody. The journey to protect a child from alienation of a parent and to recognize the importance of both parents of a child has not been a very easy one over these years, I'm sure to many of you in this room. However, for the sake of the children, we must never give up the journey. We must persevere until the child is made safe from all harm, including that of PAS. But there any questions that you may want to ask? There's lots of, I hope it wasn't too dull, because I know law stuff is very dull to everybody.
We've been painful.
Pardon?
We can only take maybe 3 questions because our schedule is not tight.
Okay. Okay, 3 questions, okay? Because of the schedule is tight. Could I?
Can you tell, a lot of our visitors are from not from Canada. Can you tell us what organization Real Women of Canada is?
Okay, well, that's a very nice question. Real Women of Canada is a women's organization. We were incorporated in 1983, and our purpose is to protect and promote the family. And we mean the family of mother, father, and children. And our concern has been much of the legislation has been anti-family, against parents, against mothers, against fathers, and we're working with regard to all sorts of issues relating to children, to family, and to marriage. And we've been promoting in all these years. We believe in the equality of women. I couldn't be a lawyer and not want equality, but we do believe that equality should take in consideration the effect on all members of the family, not just on women. We don't think that women should be given prominence and recognition, not men and not children. And so we're not feminist at all. Okay.
Causes some parental alienation.
In other words, you're saying, is there a way that a parent who has a child is alienating to protect the child and the custody that's right to the child because he's afraid that the other partner will come and take the child away? Have I got it right?
Yeah, the mother decides to
Well, I think it's always difficult to protect the other partner from going to court. I don't know how you can stop that. You know, it's always going to happen. One parent's going to try and get the child because they both love the child. And in most cases, I have had clients when it's, I want custody to get even with the other partner, and then they say, you know the whole shebang, everything that goes on. But most of the parents love their children, and one of the best ways to handle it is the province of Alberta, and they have compulsory mediation, not to keep the marriage together, but compulsory mediation with the children. Until such time as an arrangement has made out between the father and the mother, there'll be no divorce. So that is one way of stopping it, and then you get together in a room and you've got them mediating what's best for the child, and you get them talking and working together. Now, I know the feminists hate that because they figure every man is an abuser and women are terrified and they'll be intimidated and all the rest, but that has proven to be the most successful. I think the state of Alabama has done that, or Georgia. They have that compulsory mediation, and that is the safest thing when both parents work together to see what's best for the child. But apart from that, even if you do mediate and one parent doesn't like the result, they'll always go to court and you're always vulnerable. It's a tragedy, I know, and you're always afraid of losing that child. And perhaps that's when alienation, you try to alienate the child from the other partner. But that is not good for the child either, as we know. The child needs both the mother and father.
Which level of government laws do you think has the most impact and therefore are the ones to pursue first in terms of changing the laws to help kids? Which level?
It's a good question. I certainly think the provisions in the criminal code have to be the application of it. So many, and it's often men, are jailed for a year for so-called assault or abuse of the child, and of course that's the tool. And I would like to get that changed because you have to have evidence. In no other area of law can you just make an accusation and machinery goes into place and to push the other person out. And that to me is a lack of justice. It's not proper. And there's so many men who have had false allegations. As I say, just reviewing the case law, I think I found 50 in the past 10 or 15 years when the courts have found it was a false allegation. I would want that changed before anything else. With regard to the provincial legislation, many people are not married, they're living together, you don't have the Divorce Act, but you do have the provincial legislation kicks in when a couple are living common law, and that probably, after the criminal code, I'd want to get at the provincial government and tighten up the Family Law Act to write in a protection against PAS as well as in the Children's Law Act, because that's where most of the pain comes out of, is the provincial legislation as opposed from the federal, apart from the criminal code. Yes.
Would it not help if they were to enforce access in the same way they enforce payments, support payments? Because I believe the money follows the child. So if you don't get the money, if you don't.
You're saying that if we had enforced access, that would solve a lot of problems. It would, but there's always a problem. Excuse me. How do you enforce access? You've got to go to court, and who pays? And maybe like a human rights legislation, if a person puts a complaint in, the courts take over and handle it, that you don't have to pay. But most people can't afford to get enforced access. And the only way, if you could put a complaint in, and then the court machinery would take over and handle your case, it might be a whole lot easier. But most people don't ask for enforced access because they can't afford the litigation. Okay, I guess that's, the end. Okay. Thank you very much.
Thank you, Gwen. Once again, thank you, Gwen Landolt with Real Women of Canada. That was a
fantastic presentation. I'm so glad that you came today.